Appreciate you coming here today for our public hearing. I need a motion, please, to open the public hearing.
So moved.
Second.
Motion and a second. All those in favor? Aye. Mr. Davis, I believe you had something to say?
Yes, I just want to remind everyone, we are here on a quasi-judicial hearing. We have a court reporter present, and if you would, that means please don't talk over each other, and when you're at the podium, identify yourself. And if your name has an odd last name spelling, would you spell it for the court reporter? And that will help us keep a cleaner record.
I think Bill is indicating we can't hear you.
And anyone who anticipates testifying or speaking to the board today, if you would, please stand and raise your right hand. Let me go ahead and swear you in. Do each of you solemnly swear or affirm the testimony you're about to hear before this board will be the truth?
I do.
And also, and when you come to the podium, would you let us know that you have been sworn?
And one more thing, if you have a cell phone or any device that makes any kind of noise whatsoever, would you please mute it for us? All right, thank you. All right, at this time, ready to hear from staff.
We have a point of order, Madam Chairman. We have a motion for continuance that we have filed, and I think that would take precedent over any other presentation at this moment in time.
I would agree. I allow the applicant to argue his motion.
Ma'am.
Yes. Mm-hmm.
Thank you, Commissioners. We filed a motion for continuance, or a letter requesting a continuance on August 31st, and I'll get to that in a minute. But I think it's important to understand the history of the NOPC, if you will, the filings and the hearings that have been set before you, to be able to understand why the continuance request is made. And I forgot, I'm sorry, my name is Dana Matthews, and I represent Sandestin Investments, LLC, which is the applicant of an NOPC, as well as a related amendment to the DRI pursuant to Section 380.06, Pren 19, Pren E, Pren 2. We, as y'all know, I mean, we had this hearing in June of 14, and in July of 14, there was a non-compliance resolution that was adopted by this board. My client, myself, our consultants, Mr. Davis, Ms. Noyes, Mr. Jones, and Ms. Bradley met for months trying to determine the scope of the NOPC, the methodology, et cetera, and OPC, and the related amendment was originally filed in September of 2015. That went through TRC, I think it went to TRC, I don't remember now, but anyway, it was scheduled to be heard by the Planning Commission in November. We got the initial West Florida Regional Planning Council comments back, and we went to Planning Commission, and Planning Commission approved it with conditions. Meanwhile, FDOT had written a letter, and right before the Planning Commission hearing, they had some comments that weren't part of the NOPC. We had meetings with FDOT after the Planning Commission and filed an amendment in September of 2015 to address Planning Commission comments, staff comments, and FDOT comments. Thinking that by the way, then it was set before y'all in December of 2015 to be heard. BCC wanted a continuance. We agreed. It was reset, I think it was for January 21st. I think everybody believed that we were going forward on the December 15 NOPC at that time. On January 7th, FDOT sends a new letter raising additional issues that were not raised before in prior correspondence. January 13th, Tommy Barfield wrote a letter to Madam Chairman offering to conduct a transportation study if that's what the county wanted. And on January 21st, all the applicant, our consultants, and as well as the other stakeholders, appeared for a hearing. And before the hearing began, a motion was made and seconded and unanimously approved by this commission to request a transportation study before they would hear anything with our NOPC. And nobody knew how long it would take, but we agreed to have the lawyers work with Mr. Davis to try to come up with a date, which was agreed to eventually. I think it was April 21st. There were meetings with FDOT, their consultants, the stakeholders and consultants, staff, and to determine the methodology of a traffic study. And then Thursday, late afternoon, before the Tuesday, April 21st hearing, a VHBRB, which is another consultant, not FDOT, sends out a traffic study, not on FDOT letterhead, no FDOT letter, no comments from FDOT, sends it out to our consultant and to staff, and we come to a hearing on Tuesday that nobody's had a chance to review or know what the agency comments are to that particular study. We asked for a continuance of that to have an opportunity to review that and to get agency comments to that document. Meanwhile, we had filed another amendment based on the January letter from FDOT on March 15th, so that was what was going to be heard, but we hadn't gotten any comments back from any state agencies on that. So for the last 4 months, I have worked diligently, and our consultants with FDOT, DEO, and West Florida Regional Planning Council to get their comments to the March 16th NOPC, to get their comments and interpretations and the significance of the VRB traffic study, which, by the way, I told you this last time in April, was based on incorrect data. It wasn't based on all our NOPC, but we don't have to get into that now because that's really not the important point. I believed that we were going to have those state agency letters for you long before today. We don't have them. I can only do so much. I can't make a state agency do anything. I can tell you what the latest is, and I told this to Mr. Davis on August 31st, and I talked to him again yesterday. The gentleman that I've been talking to at FDOT is it's gotten up to a higher level than where it was before, and they're working with the central office out of Tallahassee, told me as late as yesterday that he actually had a conversation with Miss Bradley several days ago and explained to her what their position was and that they did not determine any regional impacts, but they do not have the letter. It goes through a process, and they have to get the letters to the West Florida Regional Planning Council, and then they turn around and send it to the county. And I talked to Sherry Spires at DEO. I've had many conversations with her. They're waiting for the FDOT letter, but it would be unfair when this commission asked us, and actually against our wishes on the first continuance in January, because they wanted the traffic study, and we have these letters that are being sent out, and we don't have any additional responses. It would be unfair for us to have to try to proceed with that being in back of everybody's mind, because y'all aren't going to listen to me when I say I talked to this guy at FDOT or this guy at DO. Y'all want to look and see what they put in writing. And we're waiting for those state agency reviews. And I believe that they'll be forthcoming. I can't tell you exactly when, because I asked that question yesterday. I said, I know I'm going to get this asked to me tomorrow at this hearing. And they've known the hearing date. It's not like they didn't know that we were having this hearing on the 9th. But it is what it is. And I think it would only be fair to give us 60 or 90 days, not just us, stakeholders, county staff, to review the state agency letters that we anticipate will be shortly forthcoming, so they can be evaluated and properly vetted, and the consultants to review them to be able to present to you at an OPC hearing. Just so you know, I've marked this as Exhibit 1. If I may pass this around. This notice.
Dana, I assume you want to move this letter into evidence?
Yes, I am.
It's the letter you wrote to each of the councils?
Yes. Well, I didn't write it to the council because I wrote it to you.
Copied it to council, yeah.
And I copied all the lawyers in this room.
And it's dated?
August 31st, 2006. I've already marked it as SDI Exhibit 1.
Hang on a second. Does anyone have any objections to the letter coming into evidence?
Not from staff.
None from staff. Anyone else?
None from your side too.
Okay. There are no objections to the letter, Madam Chairman. I would recommend you accept it into evidence as Petitioner's Exhibit 1.
It is accepted.
Thank you.
And again, this letter, because as soon as I got talking to Tim Smith, not knowing whether I was going to be able to get these letters, and Sherry Spires. I did not want people, not only our side, but the other stakeholders and the county staff and their lawyers, and spending money and time preparing over a holiday weekend, trying to get ready for this hearing, if we were going to be moving for continuance, because that wouldn't be the right thing to do. So I picked up the phone, talked to Mr. Davis, talked to, I don't remember if I talked to Mr. Stewart, I may have exchanged texts, I don't remember. Talked to Gary Hunter for SOA, left detailed voicemails for Mr. Theriak and for Mr. Heath, and sent this letter that same afternoon and emailed it to everybody. So everybody would know what the situation was, and that there would be no reason to spend money and time coming here today when we were not adequately prepared to address all the issues with the lack of the state agency responses to the last NOPC. So we respectfully ask that you continue this till 60 to 90 days, first week in December. I mean, whatever is this commission would feel appropriate, but I think that you need to time it, and maybe it needs to be, I don't know, it has to be a date certain. Mr. Davis, I guess, can opine to that. To give obviously everybody an opportunity to review whatever those state agency letters are, and that's what our request is today.
Does anyone have any questions? Mr. Matthews? No? All right, thank you.
Thank you.
Renee, staff, would like to hear from staff at this point.
Greg Stewart on behalf of planning staff. We oppose the continuance. This matter, historically, as Mr. Matthews has indicated, staff has worked with the applicant prior to the filing of the NOPC for probably a year and a half, close to 2 years, to try to flesh out these issues. We were unable to get an agreement on an NOPC, and as a result, the compliance hearing was heard over 2 years ago. This has been continued 4 times. This will be the 4th time. And if I understand correctly, the only basis for a continuance is they have what DOT says, but they don't have it in writing, that there's no regional impacts. We believe that that's not going to be a significant issue in this case. We might as well go forward and get this over with. It's going on and on and on. Certainly there is no reason for a 60 to 90 day continuance. Whatever information they need in terms of finalizing, 30 days should cover that. So we would object to the continuance. We think that at this point in time, it has been hashed through so many times with so many issues, it needs to be brought to closure. And that we would ask that the board hear the case today.
Thank you. Would any of the other attorneys like to address?
Good morning, Madam Chair, board members. I'm Gary Hunter from Hopping Green and Sam's on behalf of the Sandestin Owners Association. Like Mr. Stewart, we would ask that this continuance be denied, or certainly that a 90-day or 60-day continuance not be granted. And I don't need to go back through the history, but here's the deal. If a 18-month process of this application is still uncertain from state agencies, and we're not talking about having a hearing on what we've all been able to process, the latest iteration of which was the March 2016 amendment to the NOPC application, then withdraw the application, resubmit it. We'll all get clean state agency comments based upon whatever the application in its current iteration happens to be. This board and your staff will get a chance to look at it and see whatever has changed from March 2016, taking into account whatever agency comments come in and being able to incorporate those into their staff reports. And we'll all know what we're looking at. Your citizens, who we've had a public noticed hearing dating back to December of last year, have seen a staff report that related to the October 2015 Planning Commission. Then there was a continuance of that hearing because it didn't get finalized after 8 or 9 hours of Planning Commission hearing to November of 2015, at which point the Planning Commission took their vote and made their recommendations. Then the public hearing was set for December of 2015 before this board, as Mr. Matthews pointed out, and there was a staff report related to the changes that had been made to accommodate the request at the Planning Commission hearing. Then the continuance in January and more changes to the NOPC in March of 2016. Then in April in 2016, we had an updated DOT report, and now apparently, according to Mr. Matthews, and I'm certain he's accurate, I have no reason to doubt what he's saying, we're going to get another DEO letter, another FDOT letter, and potentially another Regional Planning Council letter. Addressing what? And different than what they had said before, I suppose, or there would be no reason for them to send another letter. So at this point, I'm not even sure. And then, and I don't, I'm not, the date of the August 31st request is not, I don't think, coincidental to the fact that there was an election on August the 30th. And so the board members and the staff and the people that have been responsible for all of this is going to change if we go past, I don't know the exact date, but I presume sometime in late November, just by virtue of the fact that an election process has occurred. And so a new body that I'm speaking to is going to exist at some point in the near future. And if that's the case, then submit a new application and let those individuals, whoever that body is, sit here and direct your staff and review this process in accordance with whatever happens to come in at that time. And let's not continue to perpetuate continuance upon continuance. If there is a continuance and we're waiting on a letter from DOT that's imminent, let's have a hearing. I mean, everybody's ready to have the hearing. I think Mr. Matthews and his team's also ready to have the hearing pending getting those letters. And let's have it in front of this board sometime in the next 30 days. I mean, in October, let's set a date and have the hearing. But coming back over here, all of us to continuance upon continuance is not good. I think for y'all, for the citizens of Walton County, for the 3,800 members of the association that are owners within Sandestin that I represent, many of them are not resident owners, but yet they try to participate because they've got an investment in that property and that project that they're interested in, and this has become a frustrating process for them. And I know for everybody, I'm sure Mr. Becknell would say he's been frustrated by it too, but at some point, pull the plug, let's start over so that we all know what we're looking at, or let's have the hearing. And thank you for listening to me.
Mr. Heath?
Yes, thank you. I'll be very brief. Sean Heath on behalf of the Greater Driftwood Homeowners Association. Driftwood, of course, is about 1/4 of all of Sandestin and has more bay frontage than any other aspect of Sandestin. Our folks have significant stake in this process and this issue, and we have, like other people, our client has a lot of money repeatedly to come here, prepare experts, and there's a point in which the continuances cease to be fair to the people who have something to say about the application in opposition to it. So we also don't think there ought to be a continuance of this, and the board ought to go ahead and make a decision requiring withdrawal or have the hearing today and go ahead and from our view, deny the application and get this thing to resolution. I also concur absolutely with Mr. Hunter in that it is not efficient for the county's resources or for the citizens' interest to have a new body evaluate this issue after it's been in front of this body so many times. So that's all I have to say. Thank you for listening.
Thank you. Any other attorneys? Okay. All right.
Good morning, David Theriak. I represent Beachside 2, who is at ground zero. As you know, Finn's is being proposed for a high-rise in this application, which is immediately adjacent to the Beachside 2 condominium. I will be even briefer than Mr. Heath. I will incorporate by reference what Mr. Stewart, Mr. Heath, Mr. Hunter all stated. And I think the most cogent reason I've heard is that you all have had this before you for so long. And if you're inclined to grant the continuance, let's do a brief continuance so that we have it before we have new folks sitting at the table. I think there's more than enough time to have that take place. So we ask you to either deny the continuance, or if you grant the continuance, set it 30, 45 days out. Thank you.
All right, any other attorneys? Okay, if not, I'll take public comment at this time. Alan?
For the record, Alan Osborne. As somebody who's spent a lot of money on this issue, I don't think the continuance should be granted. In fact, I think it should be heard and denied. And that year that you got to wait for the reapplication should be spent on making some kind of measurable accomplishments towards compliance. It's crazy to think that telling us on the 31st that so we would save money on our experts. This is a serious issue. Our experts started forming their opinion probably 45 days at least ago with all the final information. And they reviewed it, and they were ready well before 10 days prior, and we've already paid them to do it. Waiting for a new set of letters means every time a new letter comes out, I get to pay my expert to reassess the opinion 9 days beforehand. What's fair about that? None of our citizens know. The signs are long gone. This has all changed. 2 of your board members won't have heard of any of this. It should just be flat denied, just for money, just for general purpose. I don't even know why you're in the middle of it. But these facts remain. That thing's out of non-compliance. And your non-compliance to traffic is an issue, yes, but your non-compliance is for open space. So it really don't matter, like somebody said. It's been out of compliance probably since 2000. I've got the paperwork. I've told you since 2004. You came to the same conclusion with the same facts that hadn't changed since 2000. When you met your conclusion, it was in non-compliance. And there's been no measurable change for anybody to bring it into compliance. Just motions and definition changes and studies, but nothing on the ground has changed except more buildings have been built. Now, the only place to acquire that open space is in Driftwood. And the only way that open space can be there is for the drainage to be fixed and sidewalks put in like the rest of Sandestin, so that space can actually be open space and be recreationally used. But short of that, it's a ditch. It ain't open space, and it's a county right-of-way that conveys water and will never be open space. And there is no other chunk of land other than Driftwood left to recover that from Sandestin. So short of somebody making some measurable, spending some money to fix those open space issues, if you don't think traffic's changed since the 1974 application, something's wrong. You shouldn't be in the middle of this. All these issues are with state agencies. Deny this today, issue a notice of violation, and don't deal with it again until it's brought into compliance and stay out of it. It's a state issue.
Thank you. Is there anyone else? Mr. McNeil?
Thomas Becknell, Sandestin Investments. I'm going to be brief. There's no one in this room more anxious to get this behind them than I am. I've heard comments about the expense of being here. I'd be more than happy to compare my expense to all of the other consultants and attorneys put together. We have worked diligently for years to reach a resolution on this problem. Mr. Stewart said that we worked with the staff and could not reach an agreement. That is not correct. We reached multiple agreements on various issues with the staff that were later not complied with. It forced us to do a one-sided NOPC, trying to incorporate all of the information that we had gleaned during these meetings. Much of the NOPC corrects historical mistakes that were made and blessed by the county over the last 40 years. All of that can be resolved when we do have an NOPC approved. However, We were here in January. We were actually prepared in December, and again in January, as you all know, for a full hearing of our NOPC. Commissioner Meadows insisted that a traffic study be done by FDOT prior to the hearing, so the meeting was adjourned and extended. We are still waiting on the results of that FDOT study. So it seems rather bizarre to me that everyone is standing up and saying, let's ignore the state agencies in this process and cut to the chase because it's more convenient for them. Well, it would have been more convenient for me to go in January. But I want a fair, I want a legal hearing on this issue. It is of paramount importance to everyone. And the only way that that can be accomplished if all of the reporting agencies have had a chance to submit their written opinion on the matter. Everybody's speculating as to what the FDOT letter may or may not say. How can you make an informed decision on speculation unless you're going to take Mr. Matthews' word for what it will contain? But I don't think he's willing to venture so far as to say that it's absolutely what it will contain, because it hasn't been finalized yet. So I'm asking you in the spirit of reasonableness and fairness to grant us an adequate extension in order to get these letters, have a chance to review them, and then we will come to you prepared for the hearing. I am leaving the country next week for a month. This was planned when I thought today would be the final hearing. So I'm going to be completely out of pocket for 5 weeks. If the letters happen to arrive during that period of time, there's really not a whole lot that can be done. And I'm too far committed into this trip with too many other people involved to back out today. So I'm asking for your consideration. We've waited this long. I'm not happy about it either, but I'd rather wait a little longer and do it right and not have it challenged after the fact. Thank you.
Thank you. Is there anyone else? Seeing none. Board? Is there anything you want to say, Mr. Davis?
Just that the request before the board is a motion to continue today's NOPC hearing, and we'll need to have a motion and a second to vote on that.
If it's too late, yeah, but one more person wants to speak.
You should take public comment.
Yes, come on. But anybody else that wants to speak, please be keyed up and ready to go.
Sorry. And this will be very, very brief.
That's fine, sir.
That's a question. My name is Don Hawkins. I'm a resident full-time, live here in Sandestin, and this has gone on a long time. My question is about the traffic study. Was it just for 98, or did it include in Sandestin? Because I think it needs to also include Sandestin. If it doesn't, it's invalid already to me.
Well, I don't think DOT could do a study. It doesn't include. No.
Am I wrong?
I
mean, shouldn't it include in Sandestin?
DOT wouldn't have the authority to do it inside.
Well, somebody could do it,
Yeah.
right?
That was my request when I asked for a traffic study. Yes, it meant internal, external, everything combined. And the only thing that's been done is 98, so.
Yeah.
Thank you.
Anyone else? All right, back to the board. I hear no motion for continuance.
Well, then we'll need a motion to deny, if that's a motion to either grant the continuance or deny the continuance.
I would move that we continue it to October the 15th, which is a Friday. That will give him time to get back from his.
I don't get back until then.
You said 5 weeks. That's 5 weeks. You'll be gone for 5 weeks. That's October 15th is 5 weeks from today.
So I guess he meant he's not leaving until next week, so it would have to be the 21st or the 28th.
21st then, October 21st.
Do we have a second to her motion?
I have a fact risk management conference that day.
I don't, but then that would only leave 3 of us, so that's,
Could back it up to the 20th, October 20th, or any time that week.
That conference is 2 days.
Okay, well, the 19th then, October 19th would be a Wednesday.
well,
The 19th's on a Monday. Oh, October, never mind.
yeah,
Never mind.
October.
October the 19th,
Yeah.
which is a Wednesday, or October 17th, which is a Monday.
I don't understand. I kind of object to, I think I've gotten 2 years older, which at my age is, waiting for us to have a hearing on this. I don't understand why we can't hear everything today except perhaps the traffic numbers and them be given to us at a later date and then we finish up. But so everybody's here today, the attorneys are here, staff is here, we're here. Why can't we hear up to a point and then if we want to continue it? But as I say, this has been going on for as long as I can remember.
Well,
Madam Chair,
I
let me stop
Yeah.
just for making sure we have order. We have a motion, I think, for the 20th,
21st.
I'm sorry, is it 19th?
The 19th.
19th, yeah.
We just need to see if there's going to be a second to that.
Is there a
motion.
second to that motion?
Okay.
So the motion would die for a lack of second. So we'll need a motion to either grant or deny the continuance.
I'll pass the gavel. I'll make the motion to deny the continuance.
I'll second for discussion.
All right, we have a second. Oh,
Motion
I'm
and
sorry.
second. For discussion. Commissioner Chapman.
Like everybody in this room, we've been going over this thing for a significant period of time. Apparently, there's still some outstanding studies and data or whatever else to be submitted. And for myself, I would prefer to see everything. It seems like every time we get to a point, it's an amended, and it's amended, and it's amended. So I'm of the opinion we need to have this thing finalized one time, bring it all in there after you received all your data. That way you should be able to address whatever comes out of those particular letters from the state agency. And let's put this thing to bed once and for all.
So why wouldn't you do that? Why wouldn't you give them 30, 45 days and bring it back in October?
Well, I'm
You're
just,
going to have all the data by then.
maybe so and maybe not. We've been told.
Well, you might
some
not
of
have
this
it,
stuff.
you might not have it after December either.
May not have it after January.
May never have it.
They never have it.
Yeah. So, that argument to me is, I'd be glad to hear it today, but I'm thinking that gives them a chance to get the letters back. But if you deny the continuance, they are going to withdraw it and bring it back.
It's their option.
Do they have to wait a year to bring it back?
Commissioner, I've heard that. I'm not sure. I couldn't give you an answer on that.
Okay.
I just don't
Okay.
know.
So,
I don't think so. My gut is I don't think so, but I
Yeah.
have to check and make sure.
Does
so they have to
anybody-
resubmit, re-advertise,
Go back to Planning
and,
Commission.
and Planning Commission, and then the whole thing. Okay.
Any other comments from the board?
Well, I'm torn. I don't, now that you put a new prospect in here of us putting it off even longer, I don't want to put it off. I think we're ready for the most part on everything. And as I said, one of the attorneys said, isn't this about open space? The traffic, we wanted some of those studies, but this is basically about open space. And don't we have all the information that we need now to rule on open space? So that's the reason I want to go ahead and continue. Let's rule on open space. If you want to hear something about the traffic later, but I certainly agree, think it needs to be done before, we change seats here because I think that's important.
Well, and that was why I made the motion to continue it to October, to give them the time. If they withdraw it, if you don't continue it to a date certain, they're going to withdraw it and they're going to resubmit it, and you're going to be hearing this again probably this year next time. Still, in my opinion,
Yeah.
but
Wow.
So restate your motion was to,
Was to deny the, okay.
But you're basing that based on that we're going to hear the open space today. They're going to withdraw it if we deny the continuance. So
I mean-
they've already said that.
Have they said it in here under oath?
It's part of this letter.
Okay.
It's part of their letter. Oh, yeah.
Haven't had time to
Oh,
read the
yeah.
letter yet.
You can read it here. It says, lawyers, my client does not intend to present today, and we're going to, they've authorized withdraw the NOPC and related E2 amendment, which will be filed later. So, that's the choices.
So we have a motion, we have a second. Any other comments from the board? I'm of the opinion that I like to have everything ahead of time. I mean, that's just how I operate. So I like to have evidence. If there's pending letters, then I really would like to see them. So that's my only comment. Any other comments before we take a vote? Okay, motion, second. All in favor to deny, say aye.
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 Nay.
So we have denied.
Madam Chairman, may I approach?
Yes, sir.
Moved in Devon's Sandestin Investments, Exhibit 2. Letter.
Hang on just a second, just to make sure we have a clean record. Each of y'all take a look at it, make sure we have no objections to the
And
exhibit.
give us 2 seconds. That's
Yeah, give us
the
2
problem with handing something out.
We can guess, yeah.
It's a letter dated today's date, and Sandestin Investments is withdrawing the NOPC application and its related amendment filed pursuant to Section 380.0619E2. So we will not be presenting today, and we will be refiling. I have a request for the commission. The last time, for the first time in the history of DRIs in Walton County, and NOPCs on all the 5 DRIs, the staff insisted that my client send certified mail to 4,800 unit owners within the resort for the application for the NOPC to the tune of about $43,000, as opposed to what it used to be in the past, is that you would post the entrance ways into the resort. Because this has been pending for so long, and because you have all the lawyers for all the stakeholders here, and we have a wonderful thing called email today, and you can put the burden on us to provide notice to the lawyers who have been present on the new application. We would ask that you not require us to send certified mail to 4,800 homeowners, but to allow us to post the property and to send emails and to notify these other lawyers so that we're not wasting money. That's my request.
Dana, I didn't know you were going to make that request, and frankly, I haven't had enough time to research the issue. So what I would suggest is you hold that request in abeyance and let me discuss that with, let me do some research and discuss that with staff before we make a recommendation to the commissioners.
Okay. When will I have an opportunity, do you think, to get a response?
To be honest with you, it would probably be in October. We're kind of wrapped up in September, so it would probably be in October.
Okay. Thank you.
I will make a comment on that, though. Yeah, it costs money to notify citizens. Yeah. Democracy has a price. And refiling something has a price. And I think that it would be a slap in the face to the citizens to let them slide by on that one. I mean, they've been slapped enough, and I think that that's just adding insult to injury.
Anything else? Then I need a motion to close.
Hang on, let me
Okay.
make sure we have a good, clean record. Dana, you've moved this into evidence.
Yes, I did. And by the way, the clerk I apologize. I hand wrote on the one on the clerk To add the
E2
related
to-
amendment, E2. I'm sorry, I didn't have a chance to write on everybody else. But
I'll give her a clean.
So just so we're clear, you're withdrawing both the SDIs, NOPC, and the E2 change. And Madam Chairman, if you'll accept this letter to evidence.
Yes.
It's been accepted, and I will communicate regarding the notice issue. And then we'll need a motion to adjourn.
No, we need a motion to close the public hearing first.
No, yeah, you're correct.
Motion to close the public hearing.
Second.
We have a motion and second. All those in favor?
Aye.
All right, and we need a motion to adjourn.
So moved.
So moved. Second.
All in favor? Don't have to ask.